challenge was a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your Lordship under 189 protects the second, not the first. If the Governor's action is bad, will 189 ever protect it, Malas? Mr. Malas, friends, two of them argued at great length on 189. Did they answer the question? Ultimately, the core question Allah is just formulated either way, this way or that way. Is the Governor valid or not valid? If your Lordship holds him to be invalid, 189 comes only after your Lordship holds something to be invalid. Otherwise, it doesn't come into play.
It is said in the context of the vote in the House.
So,
with respect to.
Exactly. So, therefore, no. 189, your Lordships can and may, and in this case, perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, Balas. I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what
Maharashtra government made a liquor policy, therefore that is gone.
What you're saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid. Correct. But that does not validate the original appointment itself.
That's the one sentence pithy summary. Just give me a minute. Come to D, 8D. 8D. Or calling for, that goes back to the same thing, Wallace. First act was what? The Governor being approached, Governor calling. The two others are consequences. Voting is a consequence of the Governor's illegal act. So is the oath taking. If the original act is bad and your Lordships can't validate it, then this will not validate the vote. Well, the consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot.
What you're saying is that if the calling of the voting in the House itself is subject to.
That's how my Lord's formulation was, right or wrong. Governor's action, A, no basis. And B, if basis, well, it is wrongly applied, etc.
But that's affirmation of the House, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bommai dealt with the affirmation.
All right.
Bommai said, we hold something to be illegal. Let's kindly give you a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, you will be quashed. Can you come to that now? So, first, well, let's come to, yes, I'll just show 350. Just keep 356. Sima's query answered by Bommai. Para 4 of my note, this note. Much worse, fellas. Here there was nothing, in our case there was nothing. There was a presidential proclamation affirmed by Parliament in Bommai. Now come to fellas, para 4. It is respectfully submitted that the said contention is misconceived, liable to be rejected in Bommai. Does my Lord have it, fellas? Para 4. Do my Lords have it?
Yes.
Considered the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation when it is questioned before the Constitutional Court held a clear majority, 5 judges, that if a proclamation on 350 is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your Lordship is told 189, this is express approval. This is express approval. Now read this para, very interesting. 110 Justice Sawant for Justice Kuldeep Singh.
We'll check this up. We got the point. I mean, you're saying that the Bommai has a.
Now there is one interesting, very interesting. After 29 years and 2 days, this is happening in the Lordship's court. This para 110, that bold-face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books below say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you are citing our ESCR, Dr. Singhvi.
No, this is, we've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out, then the SCC issued a corrigendum. Now, the word invalid here is by corrigendum the correct word. It is in the SCC valid. So it can't be valid. Just note that. What is the legal consequence of actions taken by the President if the proclamation is invalid, yet it is approved by both houses? Come to 111 Lordship. You see, I am racing only on the underlined portions. The proclamation will not make any difference to the legal status. Express approval. Forget 189. Parliament expressly approves. The action will undoubtedly be illegal. Then we'll skip 10 lines. there is no reason why the Council of Ministers and the Legislative Assembly should not stand restored as a consequence of the invalidation of the proclamation, the same being the normal legal effect of the invalid action. In the context of constitutional provision which we have discussed, and in view of the power of judicial review vested in the court, such a consequence is also a necessary constitutional fallout. Necessary constitutional fallout.
Get the point.
Unless such result is read, the power of judicial review is nugatory and meaningless.
There is a constitutional permissible, it's permissible to have a complete restitution, is what you say.
Otherwise, it's meaningless and nugatory. The 9 judges say that, and next sentence highlighted. Hence, the necessary consequence of the invalidation would be the restoration of the ministry as well as the Legislative Assembly. Then para 114, boldface. Secondly, the court may invalidate the proclamation whether it is approved by Parliament or not. The necessary consequence of the invalidation could be to restore the status quo ante. Therefore, to restore the Council of Ministers and the Legislative Assembly as they stood on the issuance of the proclamation. So, if your Lordship is otherwise convinced, your Lordship needs no support than more than a 9-judge bench, which is very clear. It may, however, to be made clear, next sentence is very important, next boldface. It is, however, to be made clear that the interlocutory relief that may be granted on such challenge to prevent frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its function. And then to conclude, the court in appropriate cases not only be justified in preventing holding of fresh elections, but to be duty bound to do so by granting suitable interim relief. Then, they summarize the conclusions, which I will not read to save time. Clearly, para after para is devoted by Justice Sawant and Justice Kuldeep Singh. And just see 7, the another phrase, molding of relief, big Roman 7. Well, otherwise, what's the point your Lordship is exerting so much? Well, if your Lordship comes to that conclusion with great respect, and that to a court with 141, 142 and special powers, well, I can understand the High Court possibly flinching. According to me, even the High Court has the power to do it under your Lordship's judgment. Now, Justice Jeevan Reddy said this, fellows. Even in case the proclamation is approved, it would be open to the court to restore the state government to its power. If this were not conceded, look at these words, fellows, 9 judges, 29 years ago. If this were not the case, the very power of judicial review rendered nugatory, entire exercise meaningless. The court cannot grant the relief flowing from the invalidation. It may well decline to entertain. Well, they say if you can't grant the relief, why did you entertain? That's what this court is saying, 9 judges. And then Justice Pandyan, just 2 lines. Above 4A, I find myself in agreement with the opinion of Justice P.B. Sawant on conclusions 1, 2, 4 to 8. This includes my conclusions, fellows, which I just read, 4 to 8. So this is, fellows, the 3 points are covered, prohibitory, affirmative, 189 and, fellows, resignation. Now, fellows, the 4th point is this, fellows, prospective and retrospective of the EC. They're all important queries which fell from my Lord. My Lord, the Chief Justice asked this question more than once.
That is C.
That is, fellows, my C. My Lord is right. Pages 8 to 10.
Page 8.
Just, fellows, forget everything else. I'll take one point here is enough. Fellows, whatever else your Lordship holds, on the bare text, textually and facially, symbol order number 15, has to be prospective, fellows. Forget all the, we'll come to the interpretation. Just read the text, facially. That's it, para 15A of my note.
Yes.
Without anything more. We'll come to the consequences. Well, as drafted, facially, without any interpretation, it has to be only prospective. Kindly read. Power of the Commission in relation to splinter groups. Now, I've underlined some words. I've taken the liberty of underlining some words. When the Commission is satisfied on information on its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the Commission may, after taking into account all the available facts and circumstances, and hearing such reps of the sections or groups and other persons who desire to be heard, decide that one such rival section or group or none of such rival groups shall be binding. Well, this cannot but be futuro. Number 2, look at the consequences of holding otherwise. There will be, very, very strange consequences. 2 things, fellows. If your Lordship were to hold the 19th July, that's the date, order of the EC. 17th February 2023. I'm sorry, 17th February. Petition is filed on 19th July. 17th February is the order. Now, fellows, the order to be retroactive, question number 1, retroactive from when? There are 3 possibility retrospectivities. Look at the consequence. Well, Lordship doesn't hold it to be without the consequence. 3. One is, it is retroactive from the date the Shiv Sena was recognized as a 29A political party. That was in 1990 or 92. I'm giving you 3 alternatives. I'm not... because today I am the Election Commission, I hold that this is the Shiv Sena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. And third, it goes to 19 July when the petition was filed. There are only 3 possibilities, Malus. In all of these, the consequences would be that, Malus, actually everything, I would be guilty, but I am actually, I mean people who have remained with Mr. Thackeray. I'm just using a phrase because there's no other phrase available, and people who have left. Now, the people who have followed the 10th schedule and remained with Mr. Thackeray would be actually liable for disqualification, if your Lordship relates back that. So, your Lordship would be giving a premium to those who follow the 10th schedule, and the people who have not followed the 10th schedule will protect their disqualification also and disqualify me also. Whereas your Lordships will not avoid the inevitable consequence by balance. Of course, your Lordship's words can always balance, but that's the logical consequence of retroactivity. They would make an arc of immunity for their own disqualification and actually be liable because the party from 19th July, any whip, any order, everything, I have violated because I am not the party from 19th July. And therefore, I am liable to something, or from actually, logically speaking, from the origin. Therefore, this... And it would have the strange effect of the election of Mr. Uddhav Thackeray in 2018. Would also go without there being a fresh election unseating him.